are here to begin our jury selection process. However, it's come to my attention that there may be a change of circumstances. Ms. Peoples, is that correct?
Yes, sir.
Okay.
Yes, Your Honor.
If you and your client can go ahead and approach the podium. Doug, if you would approach the bar.
Where do you want me? Right here?
All right, Ms. Peoples.
Your Honor, on behalf of Aiden-Fucci, we enter a change of plea at this time, entering a guilty plea as charged.
And this is a straight plea to the court. In other words, this is not a negotiated plea, is that correct?
Your Honor, we have presented several defense offers, and they've all been rejected by the state.
So it would be a straight plea to the court.
Yes, Your Honor.
State, can you make sure that we state for the record the possible penalties that Mr. Fucci is facing if he enters this straight plea?
Yes, Your Honor, he's facing a possible sentence of life imprisonment. The mandatory minimum would be 40 years. So similar to after trial, the range of exposure is 40 to life. He will be entitled to a review hearing after 25 years of serving any prison sentence, Your Honor.
Ms. Peoples, have you had sufficient time to talk with your client about this decision?
Yes, Your Honor.
In addition, are his parents aware of this disposition, proposed, not the disposition, but the proposed plea?
Both parents, yes, Your Honor.
And they've had an opportunity to consult with you as well as Mr. Fucci?
Yes, Your Honor.
Are there any other matters we need to address at this time before I place Mr. Fucci on the road?
No, sir.
All right, Mr. Fucci, if you could step over and speak into that, if you could adjust that microphone. Sir, if you'll raise your right hand, you swear or affirm the testimony that you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, sir, if you please state your name.
Aiden-Fucci,
Mr. Fucci, how old are you, sir?
16.
How far did you go in school?
To 8th grade?
Are you able to read, write, speak, and understand the English language?
Yes, Your Honor.
Are you under the influence of any medication, drugs, or alcohol right now?
Yes, sir, my medication, but
What type of medication are you taking?
Rimrons, lithium, and Suprexa.
Is that medication prescribed by a physician?
Yes, sir.
And does that medication assist you in your ability to understand what's happening and going on around you?
Yes, sir.
Have you taken that medication today as prescribed by your physician?
Last night, sir.
Last night, is that when you were scheduled to take it?
Yes, sir.
All right. And is it in any way, shape, or form affecting your ability to understand what's going on here this morning?
No, Your Honor.
Do you feel clear-headed and clear-minded about what's going on here today?
Yes, Your Honor.
Have you ever been diagnosed with a mental health condition that could affect your ability to understand and comprehend what's going on today?
No, I don't believe so.
Your attorney has informed me that you'd like to enter a plea of guilty to the charge of first-degree murder. That is a sentence that is a crime which is punishable by up to life in prison. The minimum sentence that the court could impose would be 40 years in prison. You just heard the state outline that range. Do you understand the range of possible penalties that you're facing if you enter this plea today?
Yes, Your Honor.
You understand that the minimum sentence that this court could impose for you would be 40 years in prison. You understand that?
Yes, Your Honor.
And the court could impose all the way up to life in prison. Do you understand that as well?
I do, Your Honor.
And the way that this works is if the court were to sentence you to 40 years up to life, you would also be eligible for a review sentence of that sentence in 25 years. At that point, another body would then come back and review what we're doing here today, and they would look at that sentence and determine whether or not they should change that sentence. However, that's no guarantee as to what they're going to do. That's just something in the statute that requires another body to review this court sentence in 25 years. Do you understand that as well?
Yes, Your Honor.
Has anyone promised you any particular sentence that I might impose if you do this?
No, sir.
No one's said, hey, if you enter this plea today, the judge might, go lighter on you or anything like that? No one's promised you anything like that, have they?
No, sir.
You understand, again, I could give you 40 years up to life in prison.
Yes, I do.
All right. You understand that today, we are here for jury selection. So we actually have members of St. Johns County who have reported to the courthouse today downstairs. They're actually waiting for us right now, and we were going to begin to select a jury to conduct a trial for you. You understand that you have the right to that jury trial?
Yes, sir, I do.
Your attorney had filed a motion, and we had a hearing a few weeks ago, I guess, where she had, the state had requested a 6-person jury, and your attorney requested a 12-person jury. Do you recall that hearing that we had on that?
Yes, sir.
And you also understand that right now your attorney has filed a motion to an appellate court, which is kind of a higher court above this court. And their responsibility is to review all of the decisions that go on here. And right now, she's filed that appeal as to whether or not you were entitled to a 6-person or a 12-person jury. You familiar with all that?
Yes, Your Honor.
Did you and she discuss the fact that by entering this plea today, you're kind of taking away that issue? In other words, there's not going to be an appeal anymore. Do you understand that?
Yes, sir, I understand.
Once you enter this plea today, that's going to go away. You understand that as well?
Yes, sir.
Is anyone forcing you or threatening you in any way to get you to do this?
No, sir.
Has anyone promised you anything in exchange for your plea?
No, sir.
I have a document here, it's called a plea form. It has the state of Florida versus your name and our case number. On the second page of this document, above the word defendant is a signature. Can you see that signature I'm pointing to? You
Yes,
have a
sir.
copy of it in front of you as well, is that right? Is that your signature?
Yes, sir.
And by signing this document, are you indicating to me that you've read this document?
Yes, sir, I read it.
In addition to reading it, did you discuss it and talk about everything that's on it with your attorney?
I did.
Did she answer any and all questions about everything that's contained on this document?
Yes, sir.
There's a number of rights that you're giving up. I've already talked about them a little bit, but I want to talk about them again with you, okay? You understand, again, that you have the right to a jury trial. During that trial, you're entitled to be represented by an attorney. You've got attorneys who are appointed to represent you. They would have been with you throughout that trial. You have the right to compel witnesses to come in and testify on your behalf. You could have testified during that trial if you wished, or you could have remained silent throughout that trial. You could have required the state of Florida to prove this charge beyond a reasonable doubt. You could have presented evidence during that trial. You could have cross-examined any witnesses that the state might have called against you. And you also could have appealed your conviction and sentence to a higher court. You understand, once I accept your plea today, there will not be a trial. We'll pass this matter off for sentencing, and you'll be giving up all of those rights that I just described.
I do, Your Honor.
Another matter that I want to address with you is another motion that we had previously discussed a couple of months ago, I believe, which was your attorney had filed a motion was called a change of venue. In other words, she wanted to have this trial conducted in a different county instead of St. Johns County. She was concerned about whether or not we would be able to impanel a fair and impartial jury. And if you recall, I ruled on that and I denied that motion. However, I stated that I would reconsider that if, after we had attempted to select a jury here in St. Johns County, if the court then determined that we could not find a fair and impartial jury for you, that we would move this to a different county. You understand that, again, once you enter this plea, that issue is not something that would be appealable anymore.
Yes, Your Honor.
You understand that now, that we're going to proceed here today with this plea, and so you'll be giving up that appellate right as well.
Yes, sir.
Have you had sufficient time to talk about this decision with your attorneys?
Yes, sir, I did.
Did you also get a chance to discuss it with your parents?
Yes, sir.
Have you also had sufficient time to talk with your attorneys about your case itself and any possible defenses that you might have raised through this charge?
Yes, sir.
I know that you were housed up in Duval County. Did that in any way preclude your ability to speak with your attorneys? Have your attorneys been able to meet with you and have conversations with you about your case?
They did.
Did you get to go over the evidence that the state has and that they've supplied in discovery? Have you discussed all that evidence with your attorneys as well?
Yes, Your Honor.
Do you need any time at all, any more time at all to speak with your attorneys before I accept your plea today?
No, sir.
Are you satisfied with your attorney's representation of you?
Yes, sir.
Did your attorneys explain to you that if you were not a U.S. citizen entering this plea, could have subjected you to being deported from the United States?
Yes, sir.
And you've not ever previously been convicted of any type of sexually violent or sexually motivated crime, have you?
No, sir.
State, have you supplied the defense all of the discovery in this case?
Yes, Your Honor.
Are you aware of any physical evidence that can be tested for DNA that might exonerate this defendant?
No, Your Honor.
Ms. Peoples, have you had sufficient time to review all the discovery and discuss it with your client?
Yes, Your Honor.
Are you aware of any physical evidence that can be tested for DNA that might exonerate your client?
No, sir.
Does the state have a factual basis, please?
Yes, Your Honor. On or about May 9th, 2021, in the county of St. Johns in the state of Florida, the defendant, aiden-fucci, did unlawfully kill a human being, Tristyn Bailey, said killing being from a premeditated design to effect the death of Tristyn Bailey. And furthermore, during the commission of said offense, aiden-fucci used a weapon contrary to Florida statutes 78204, sub 1, sub A, and 775.087, sub 1.
Any objections or exceptions to factual basis?
For the purpose of the plea, yes, Your Honor.
You do have exceptions or you do not?
No exceptions, accepting it for the purpose of the plea.
All right. I do find a sufficient factual basis for the charge of first-degree murder. Mr. Fucci, is it your desire to enter a plea of guilty to one count of first-degree murder?
Yes, sir.
I accept your plea. I find it's entered into voluntarily, voluntarily, and intelligently, that you are coherent and alert, and that you understand the nature of the charges and the consequences of your plea.
I do.
We need to pass this matter off for a sentencing hearing. I know that this, we probably aren't ready to pick a date yet. Why don't we come back? Let's talk a little bit about what we need to do before we get to sentencing, so we hear from the state.
Yes, sir. I think if we want to state a discovery deadline where both parties have to disclose any additional evidence for purpose of sentencing, any witnesses that have not already been disclosed, and then from there, we can set a status in February if Your Honor would like, and probably pick a date sometime in February once we exchange those lists.
Pick a date for the sentencing out in March or April, is that what you're suggesting?
Yes, Your Honor.
Ms. Peoples, does that schedule work for you?
Yes, sir.
How long will both sides need to compile a list of witnesses to, for the sentencing hearing
I
itself?
believe 10 days would be sufficient, Your Honor.
All right, so 10 days from today, both sides will tender a witness list and any other discovery that they intend to utilize. Obviously, if there are letters of impact statements, things of that nature, we can expect those. But if it's anything of evidentiary value, that needs to be provided within 10 days of today. I'm also going to order a pre-sentence investigation. Ms. Peoples, are you requesting that as well?
Yes, sir.
And a predisposition report. I believe you would be entitled to that, so we're going to order both of those reports. So then we'll get working on both of those.
Your Honor, I just a special request with that order that if the court could note to the meeting DJJ and to the, I believe it would be the sheriff's office, that defense counsel wants to be present for those interviews.
I will absolutely, we will notify them as well that you should be present for those interviews. Mr. Fucci, your attorneys are going to be present with you, but there will be, there's going to be a couple of reports that are going to be compiled for the court. They're going to be used as an aid to the court in order to determine what the appropriate sentence is. There will be someone who will come out and speak with you. Again, your attorneys will be present when that occurs. They may also speak to your family members, and then also the state and your attorneys, and also the victim's family members as well. So why don't we come back on February 23rd at 9 a.m. We'll call it a status, and at that time we will select the date for our sentencing hearing. How many days do you anticipate needing for the sentencing hearing itself?
2, Your Honor.
2 days?
Stay on the state's behalf, I would say reserve one for us, plus whatever.
Okay. Well, we'll set aside, we'll find 2 days. You all tell me when you both will be ready, and then we will select those 2 days. And then any hearings or any motions that we need to address on February 23rd, we can address those at that time as well. And I believe that covers everything. Is there anything else we need to address from the defense?
Yes, Your Honor, a point of clarification that Mr. Fucci had said that he read it, I actually read it out loud to him. It's a minor point, but I just wanted to clarify that on the waiver form.
The plea form?
That's correct.
Okay, so
And-
Mr. Fucci, when I asked you about whether or not you read it, your attorney actually read the plea form to you, is that right?
Yes, sir.
And she went over all those rights that I went over with you as well?
Yes, sir.
And she again answered any and all questions about everything that's contained on that document for you?
She did.
And your parents were also present during that conversation as well? Were they present as well?
No, it was a separate conversation with the parents, Your Honor.
Okay.
And Mr. Fucci just wanted to make a short statement.
I just want to say I plead not guilty. And that I'm sorry for the Bailey family and my family.
Okay. Okay. I'm sure that there'll be an opportunity, obviously, at sentencing hearing to speak again at that time, okay?
Yes, sir.
All right, any other matters we need to address?
No, Your Honor.
Anything else from the defense?
No, Your Honor.
No, sir.
All right, well, we're adjourned. We'll see you back here February 23rd at 9 a.m. Thank you.
Board is adjourned.